They go further. Article 9 of the same agreement, they talk about compliance of the domestic laws, but at the last sentence, they say that compliance with such laws of Kenya does not impact the incentives of the company provided for in Article 5. They say that you are going to comply with all the laws of the Republic, except the law that impacts on the incentive.
Now, you know, you are seeking to support this agreement that you have entered with Blue Nile, with subsequent notices that have come into place to justify this agreement that you have with Blue Nile. You know, there is no, you can't apply a law retrospectively to an agreement that was signed much earlier.
So was this instrument, with this circular that you are using to guide your operations, was it ever brought to Parliament?
It is only Blue Nile that is benefiting from the SOFA tax rebate. Were there other applicants? And therefore, what happened to them? What is the status of their application? And just as Chair has read, you cannot come up with a law that controls competition. It has to be an open-ended market for everybody. So how comes that only a particular company applied and got, and all the rest just ignored such a very important tax rebate that everybody would want to enjoy?
Chair and members, I think I'm advised by our teams. From our end, I think we don't have evidence of it having been brought here, unless maybe from the Ministry of Industry.
No. The ministry that is charged with the responsibility of exempting taxes is yourself. And in fact, fortunately, the PS has said you are the one responsible for that department or docket. So you're supposed to tell us in certainty, are you aware or you are not aware?
I'm not aware, Chair, of that.
Evidence is glaring that all the operation, as far as this agreement is concerned, there is too much illegality. And not only that, Honorable Chair, we are in a situation where the Republic of Kenya needs to get enough taxes to be able to take care of our domestic issues. We are in a serious problem revenue-wise. So when we have agreements which are giving tax exemption, and I can assure you, Honorable Chair, and it is good for this to go on record, that we are talking about tax exemption now of about 1.3 billion from 2020. I will not be surprised if it is times 10 of this. Yes. If you earn there is huge amount of money which can take care of the problems which we are facing.
Chair, we don't have information as to having submitted this. Thank you.
Thank you very much, Mr. I think, you know, then we don't have many things to ask. We cannot ask about the substance of the agreement, the issues that are contained thereof, because it is an express admission that has never been sent to Parliament, so we have nothing to consider. You know, when I look at the amendments, it provides that in the case of a company engaged in business under special operating framework arrangement, it's an arrangement. It is not an agreement. So I don't know where you people got this idea of an agreement, where you reduced your understanding of the law to an agreement. I don't know, I've never understood how you would enter into an agreement with a private company to exempt it from paying taxes when it is a legal provision. Two, the question that we asked you is, can you prove to us that you actually table this agreement that provides for exemption of taxes to a person? And we have read to you that if it intends to restrict competition, it falls within the statutory instrument. This particular instrument was made in 2020. it falls within this particular law, which was made in 2023. And so it is incumbent upon you to comply with this law. So we want to know from you, what are the, what we want to understand from you. Where is it that you gave to Parliament this particular instrument? How did you transmit? Has it ever been brought to Parliament? You have said parties agreed to keep the contents of this agreement as well as the information shared as part of the execution of this agreement confidential, as part of the information shared. And you are doing it pursuant to a law, which is an amendment that was contained in the finance bill. Parties shall, however, be allowed to share the contents of this agreement in their respective affiliates.
Just a point of order.
Yes, not against me.
No, not against you. Are we therefore in violation of their laws for us to discuss this document? If that article or that section or that clause is anything to go by.
It is not intended to be for the consumption of Parliament. So that's the problem that I have with regard to this agreement. It's not even an arrangement. This is an agreement to exclude all other parties. So including Parliament, you are excluding Parliament from looking and examining these documents. Two, you have also excluded us from our mandate to oversight government, to oversight the executive. So we are being told that we are intruders to this agreement. I mean, that in itself is unconstitutional.